Well, welcome everybody. My name is Brian Leonard. I'm a professor of law at the University of Nebraska. I am also chair of the ILW committee on formation of rules of customary international law. That's quite a mouthful, but we just actually had a little informal committee meeting, and I would encourage any of you who weren't at that meeting to feel free to join our committee. It's very open-ended, and we welcome input from people from all areas of expertise and anyone who's interested in the relevance of customary international law. I also want to say thanks for coming in the mid-afternoon here on the last day of our international law weekend. I guess we actually have some customary international law enthusiasts here. So, and I think you'll find our panelists also have a passion for this subject. However, as you'll see, we are going to look not only at the unique role that customary international law can play in fostering global cooperation to solve a number of pressing world problems, but also its limitations in relation to other approaches, which of course is a theme of our entire conference this week, right? What are some of the limits of international law? And should we be looking at other types of solutions to problems, right, including diplomatic negotiations and so forth. So let me just highlight for you kind of how we intend to proceed. First of all, a note that we are offering CLE credit for this session, and so at the very end, I will give you the code you'll need. Also, I would just alert you that we have prepared some materials for those who are seeking CLE credit. So you can find those in the email that you should have received from the organizers. And what I'd like to do then is set the stage for our topic, which, as you know, is customary international law and beyond. What is its unique role in facilitating global cooperation? I'll give a little bit of background on what is customary international law. Frankly, everyone's trying to figure that out still, and that's part of what our panel is about. But I understand that many of you are coming from with different levels of study of this field. So I'll give you a little bit of an introduction. And then we're going to turn to our distinguished panelists. I'll tell you more about them shortly, but we have Jocelyn Getkin from Cardozo School of Law. We have Alan Franklin, who is an expert on business and human rights. And then, of course, we also have Mark Dennis, who is an assistant professor of law at the University of Connecticut. So more about them shortly. They will be sharing their perspectives, though, on this broad theme, but looking at the relevance, but also limits of customary international law in some very specific areas that they are studying. And I do want to say that our plan is to try to be as brief as we can, so that we will have half an hour for dialogue with all of you. Because I think you'll agree that one of the unique benefits of this gathering every year is that it's an opportunity for all of us, whatever our level of existing knowledge, to learn from each other and to share perspectives. So we want to make sure to encourage that, so it's not just kind of one way, we talk, you listen, but we have a real dialogue. So we're going to allow 30 minutes for that. So I will be a strict timekeeper. This is a fair notice to my fellow panelists. So just to give a little bit of introduction, I mean, no doubt you are aware that customary international law is one of the primary sources of international law listed in Article 38 of the Statute of the International Court of Justice, which it is to apply in deciding cases that come before it. And by the way, that is one of the materials that we provided for CLE credit. It's long played an important role in international law and really in international affairs. Within the realm of international law, at least some scholars have viewed it as the primary source. Right? This was the very first source of international law. And of course, why is that? Well, the definition that we accept traditionally is that customary international law arises from a general practice among states in the global system that they accept as law, that they accept as legally binding. And this definition, which has two elements, the first is a general or uniform state practice. The second element is this subjective belief that that practice is legally mandated or required or permitted, or some practices are legally forbidden. It's that belief we call opinio juris. And so this is often referred to as the two-element definition. It has recently been reaffirmed by the International Law Commission in the conclusions on the identification of customary international law, which it adopted and which were endorsed by the United Nations General Assembly in Resolution 73/203, just 5 years ago, in 2018. And I commend that document to your attention as well. It's also included in the list of documents for CLE credit. You can just click and get access to that. So that, of course, is the traditional understanding. But an important question is, how do we determine whether those elements are met, and is this really sufficient, this conceptually? Now, going back to my original point about the importance of customary international law, we can kind of see how the very first rules of conduct among states, or even before we had sovereign states, principalities, kingdoms, and so forth, developed really through a kind of habit or custom that arose among them. The custom might be related to trade. The custom might be related to conduct of war. But there was a custom, and then there came to be a belief that that custom had legal consequences. For example, was legally mandated. And then there was, in fact, a rule, right? The confluence of those two elements created a rule. And so even though today we have many other important sources of international law, of course, the other primary source we think of as treaties, even the law of treaties began as customary rules. So let me just highlight for you a key question that we'll be investigating in our panel. And you know this from the description, right? Which is, when we start to think about those two elements of customary law, we can ask some really searching questions about just how is it different from, for example, a kind of state practice that's not accompanied by belief that the practice has legal implications. So we might reasonably say, are there practices, forms of practical cooperation that we want to keep very informal without legally mandating them, right? Or creating a legal rule around it. We want to create a space for freedom of action of states to solve problems. And how is customary international law different from this kind of informal practice? And we might even humbly say, are there cases where we want to encourage this kind of informal practice? And I think we heard an allusion to that in the keynote address we had yesterday by the president of our other state organization, our sister organization, ASIL, Professor Schaefer, about creating spaces for cooperation, including in technical fields, and I think we'll hear a little bit about this, like in the business realm, without there necessarily being legal consequences and the formation of a customary law. So that's one question that we can associate with the traditional definition of customary law. Another is related to opinio juris, because opinio juris requires, to prove it, we have to have evidence that states believe that a rule is binding legally. And often that evidence may well take the form of a treaty. And for example, the conclusions of the ILC address specifically the role of treaties in either codifying pre-existing customary law or helping to create a new rule of customary law. But we often have to look for some evidence that states believe in the legally binding quality, right, of a rule that in turn is also evidenced by practice. And often we look to treaties. We might also look as evidence to, say, resolutions of the UN General Assembly. And so, in fact, I want to just say I am so sorry that, I'm glad that we got Alan and kindly agreed to step in. Rosanna, the plaintiff, was originally supposed to be part of this panel. And she's written an excellent book on the legal status of General Assembly resolutions. So sadly, she had an accident, had a personal injury just a few days ago, and was unable to come. But we're so grateful to Alan for stepping in for her. So, obviously, she was going to address very specifically the role of General Assembly resolutions. But this does raise this broader question of what is the role of agreements among states, whether informal, perhaps taking the form of a resolution of an international organization, or even just bilateral informal agreements, and or what's the role of more formal treaties as detailed written binding agreements in relation to customary law, and when should we prefer one of those approaches, like the treaty approach or the declaration or resolution approach, to cooperation versus customary law. So I think all of our panelists will be touching on those issues. So that's really my introduction, and I think without further ado, we want to make sure that, as I said, we have adequate time for dialogue with all of you. So let me just a little more quickly introduce. We're going to start with Jocelyn, and so as you know, she is, I believe, associate.
So now I'm
Full professor. Okay, that's an outdated title. Wonderful. So she is a full
do something about the
clinical
website.
professor, right, at Cardozo School of Law,
Yes.
and director of their program in human rights. And so we're delighted to have her. So why don't we start with you, and I'll be a strict timekeeper.
Do you have a specific question for me, or just one?
Okay.
Okay.
So the question here broadly for each of our panelists is, in this field that you are working in, the space you're working in, I should say that Jocelyn has worked on the modern day slave trade. And some of you may have been to the panel that she was a participant on yesterday that focused on this issue and the fact that we really find that modern day treaties like the Rome Statute have omitted explicit reference to the slave trade. And what are the implications of this, and what role can customary international law on the slave trade play, therefore? So I don't want to steal your thunder here, but that's what she'll be talking about, and then we'll move on further. There you go.
Stealing the thunder.
Sorry.
Thank you so much, Brian, and thanks to all my fellow panelists, and thanks to all of you who have an interest in this topic. So yes, I am working very much in slavery and slave trade prohibitions. I'm thinking about these prohibitions. The work that I do in Human Rights and Atrocity Prevention Clinic at Cardozo Law took me to the context of the Yazidi genocide, which also included slavery and slave trade crimes on a widespread and systematic basis. And that issue in the law then began, there were questions, right, about what do we do in terms of redress for the slave trade, especially because when you look in some of the treaty law today, especially the Rome Statute of the International Criminal Court, you do not even see explicitly enumerated the crime of the slave trade. And even when I'm talking only about the slave trade, people talk about slavery. They omit, even in response to me only speaking about the slave trade, omit the slave trade when they're speaking to me. As we know under Hogan's norms and customary international law, and I can go through the reasoning behind why slavery and the slave trade are both independently international prohibitions, international crimes of Hogan's values. So normatively, they are Hogan's and with erga omnes obligations of states, and also achieve customary international law status, both under international humanitarian law and international criminal law. At least we can point to a lot of evidence that they are a crime against humanity under customary international law. And that is still evolving law, but there's a lot behind it. And I'm still finding that we are erasing under international law treaties, especially the slave trade as a separately enumerated prohibition. And I have a lot of ideas about why we are doing that. I've studied the travaux preparatoires, for example, of the ICCPR, the International Covenant on Civil and Political Rights. It was added at the very end by Russia, but there were states that were not interested in hearing about the slave trade. And you can imagine at that time, in a post-World War II context, that the European powers, that the United States wanted to sort of maybe not talk anymore about the slave trade because of the implications for Western states in the slave trade, in the transatlantic slave trade at least. So there are lots of reasons that I would say are why we don't see the continuation of the slave trade explicitly enumerated in some of our treaties. The European Convention on Human Rights, for example, prohibits slavery, but not the slave trade. But many human rights treaties still do prohibit both slavery and slave trade. Why do I care about this? Because it has real implications for impunity for victims, survivors of slavery and the slave trade. And there are victims, survivors who are slave traded, who are not necessarily also enslaved. And this is the case because someone can intend to bring someone or maintain someone in a situation of slavery or dispose of a person enslaved. But that person, if they're trying to bring them into slavery, may not succeed. Someone may escape. Someone may get to a situation and that person that is about to exercise ownership says, I'm no longer interested in doing this, and the person is never actually brought into a situation of slavery or enslavement. So the crime of the slave trade, the prohibition of the slave trade is still incredibly important. And we need to keep it, right? And we need to keep the status alive under all of the various protective statuses in international law that we have. So because of its jus cogens status, which you can find, for example, in the restatement of the Foreign Relations Law of the United States, where slave trade is explicitly enumerated as a norm of jus cogens that has then erga omnes obligations. You also have a really in-depth analysis by Sharif Basuni, who goes through the test of whether a norm has attained jus cogens status and talks about slavery and slave-like practices, which I would argue the slave trade is one of those slavery-like practices. You also see evidence of the slave trade as customary international criminal law. The Durban Declaration pronounces slave trade as a crime against humanity. There is the EU CLAC resolution that just happened this past spring that has a statement on not only past slave trades, the transatlantic one is explicitly enumerated, but also present day exercise of the slave trade as a crime against humanity. We have evidence under international humanitarian law, Rule 94 of the International Customary Law ICRC study includes slavery and the slave trade. The Lieber Code, as Patty mentioned yesterday in the session, also prohibits the slave trade and enslavement in times of conflict. And I would also argue that one act of slavery, one act of the slave trade is also prohibited given its jus cogens status and there's a requirement of states as an international crime, the way that torture is considered to be an international crime in its own right, even though not explicitly enumerated apart from war crimes, crimes against humanity under the Rome Statute, it could have been, right? And I would argue also that slavery and slave trade could have been enumerated separately. So why do we care about this? If the slave trade has such a high normative status under international law and enjoys all of these categorizations as jus cogens with erga omnes obligations, is a customary international law norm, why then do we care so much about enumerating it within the Rome Statute? If states, whether or not they are states party to the Rome Statute, already have an obligation to prevent, punish, redress for slavery and slave trade, I would say that, the way the evolution of international law is going is that the positivists really are winning out. And treaty law is what, in practice, people are looking to determine what those norms are. whether they get investigated, prosecuted, punished, is often a reflection of, well, let's look to, for example, the Rome Statute. Let's see what crimes are enumerated, and then let's go from there. And because the treaties are enumerating the crimes and omitting others, we're actually seeing a move away from investigating, prosecuting, and punishing crimes like the slave trade. And that is, I guess, where my worry lies, is that, the arguments from a scholarly sort of, theoretical point of view is we can never have a jus cogens norm that moves away from a customary status, right? All jus cogens norms are customary, not all customary norms are jus cogens, but the other way does hold water. But from a practical perspective, you see the practice of states moving away from such prohibitions when they're not found in treaty law. There just isn't a practical place for folks to get redress, and then the opinio juris and everything is sort of stalled at that point in international law. We're not evolving in our understanding and the development of, from a practical point of view, these prohibitions and crimes in the international law space. So my worry is that if we're not pushing for enumerating customary law norms into our treaty law, so the way that Brian was talking about, sort of that reverse transmission, not just the fact that treaties are reflective of customary law, or that they're starting to encourage or starting the process of customary law, we need to make sure that both of those avenues stay wide open for these types of norms that, for very practical, political, maybe reparations kinds of reasons, states are reluctant to continue to prosecute, punish, provide redress for certain norms like the slave trade. So I'll leave it there, but I really welcome questions and comments and further thoughts on this, because obviously my thinking is constantly evolving on this as well.
And now we're going to turn to Alan Franklin. Alan has had a great deal of experience really teaching international law to business executives, but also to diplomats. So he has taught diplomatic law to diplomats from the Diplo Foundation in Europe. But he will actually be focusing today on how labor and customary international law.
Thank you, Brian. Welcome, everybody. I need to lay out firstly why I got so involved in these issues of child labor and the relationship to customary international law. For the last 5 winters, my wife, Carolyn's back there, and I go to Cambodia and I teach at the Royal University of Law and Economics, again, an executive business programs, international business and international law. And when I lived in Cambodia, and you go to the restaurant for dinner, there's kids in the restaurant all the time trying to sell you little bits of fruit, right? Or just asking for money, or just asking for food. And we started to look at this and say, what's going on? And then we realized something, that the lucky kids, the really lucky poor kids in Cambodia, Vietnam, Myanmar, Laos, they're the ones who are working in the factories. Those are the kids who are won the brass ring, because they got jobs. They could be 10 years old, 12 years old, 14. They have to work to bring home a little bit of money so that their family can eat, because there's not enough money being earned so that they can't feed the mouth of a child who doesn't bring in money. When we realized the enormity of this, we said, that's it, we got to get involved in dealing with this problem. And the other thing that got us interested was, I assume most of you would know about the collapse of the Rana Plaza factory in Bangladesh. It was 2013 or 14. And that spurred a lot of companies to, Western companies, okay, we must rid our supply chains of child labor. So they said to all their suppliers, okay, get rid of the kids. The supplier said, who cares? Get rid of the kids, don't, we don't care. We'll get rid of them. BBC does a video. What happened to those kids? Well, they didn't become PhDs at Harvard. They ended up working in worse situations, glass factories. And to pick up on Jocelyn's point, one of the ways that you get your kid to work and bring in some money is you sell them to a brick factory. It's indentured slavery. And the brick factory gives you some money for sort of an upfront fee. And that's how the family can survive while the child is working as an indentured slave in the brick factory downstream. And we would go, when we were out going to dinner, you would see the skids of bricks because there's a lot of construction going on. And those bricks were made by the kids who were the indentured slaves. They're not so lucky as the kids who are working in the garment factories, because that job pays well, can pay like $150 a month, right? But those are the lucky ones because their job is fairly safe. They're not going to be killed making jeans that probably most of you are wearing today, right? So that's what got us so involved in the child labor. And when I try, sometimes it just becomes too much for me. I say, I gotta stop. And my wife says to me, you've got an obligation to the children of this world to keep going on this, all right? So that was sort of my intro to why we're doing this. So to bring it back to the customary international law question, is child labor something that's contrary to the customary international law? That's the argument, the issue we've been fighting with. So to turn first to what Brian said, there's a lot of times treaties form the basis of everybody signing treaties that can form the basis. So I would point out, for example, the International Labor Organization has their Convention 138 is minimum age of children to work. 182 is forced labor and child labor. We have the Convention on the Rights of the Child, which most countries have signed except
All countries.
All right. Those are just some of the key ones. There's lots of other treaties that deal with child labor, and they all say child labor is bad. Well, there's different degrees of bad. Child death is worse than child labor. This is where I start coming into this. So the rules are so different. For example, the ILO convention says kids must be 18 to work, unless the country has a reason to lower it. Mm-hmm. So most countries that have signed the convention have lowered the age to 14, some to 12. Why? Because they understand that kids need to work for various reasons. So the second area is soft law. Soft law means rules that have been promulgated which don't have the force of law. They're not treaties, but they're understood to be rules that should be followed by companies particularly. So going back to my issue of business and human rights. So we have the United Nations Guiding Principles. That's from 2011. John Ruggie at Harvard developed them. They were approved by the UN. We have the UN SDGs, right? The development goals. The SDGs say the goal is to stop child labor by 2025. Really? If you read, child labor is going like this globally, and the UN is saying we're going to get rid of it by 2025. They're also talking about getting rid of forced child labor by 2030. So why they want to deal with ordinary child labor before forced child labor is beyond me, but that's the way it is. The OECD, the Organization for Economic Cooperation and Development, had the responsible business conduct rules for multinationals, talking about we have to stop child labor. UNICEF, they have the Children's Rights and Business Program from 2012. The United Nations Global Compact, they have a principle on ending child labor. So with all of these hard laws and soft laws intersecting here, the question is, well, obviously we have enough basis to say this is customary international law. Not only is it customary international law, but it's gotta be at the level of use codes, right, peremptory norms. Okay, but you also need practice of states and opinio juris. This is where the problem comes in. And part of it starts with our Western idea, which I stated before. We think, 1 minute, we think that kids, if they stop working, will go to school and become Harvard PhDs. What we don't realize is in those countries, there is no schooling for the poor. Not necessarily because they can't afford the schools, but because in a country like that, we've got a huge poor population. An educated poor population is dangerous to the country. So when they tell companies, well, you should open a school, try it and see what the government will do, because we've been there. The government will move the people who are going to your school 30 miles away so that they can't go to your school because they don't want school for them because they're afraid of it. We have to then look at the US. The US, I don't know if you're aware, but in the last couple of years, I think 12 or 14 states have lowered the child protection laws to 12. In Oregon, 9-year-olds are allowed to pick berries for interstate commerce. 9 years old. So here's the United States saying to the other countries, you must stop child labor. But we're going to really engage in it because it's good for business. And we have 300,000 kids, 300,000 people kids come in recently from Guatemala and all that who are unaccompanied asylum seekers. They're all the ones working. If you read New York Times and all, you'll see all the articles about them. They can't go to school. They have to earn because they're on loan. So they're working at McDonald's, they're working at these meat packing plants in horrible conditions. So the question is it customary international law? My perspective would be, no, it's not. Because there isn't state practice that actually seems to care about it. So I'll stop there.
Thank you very much. Now we'll turn to Mark Jennings.
Thank you very much.
So,
Hello, everybody. I want to thank our previous speakers. I don't think I need to tell you that these three people care deeply about customary international law, and so do I. But I think international law as a whole is in crisis. I think we're really in a 500-year crisis. And whether or not we're going to be talking about it, say 10 years from now, when most of us are around 29, like Brian and me, I'm not really sure. I want to go back to roots. I want to give you a radical view, not only of customary international law, but also of international law in general. And what I'm going to urge you to do is be optimistic, be idealistic, be naive. So go back 500 years. I was a mere lad at the time. 1492, the New World was discovered. 1517, Luther posted his theses on the church door in Wittenberg. Two significant developments that really created the modern profession of international law. First one that began really in the Spanish theological schools, where they debated what to do with the people who already lived in this land, the terra nullius, where nobody was supposed to live. And you had two different competing theories of thought. One, that these indigenous people were people, and the other theory was that they weren't, and perfectly reasonable propositions. And the Spanish theologians began to develop what was called the law of nations, the idea that there were certain laws that bound Christians and non-Christians alike. Moving across to Northern Europe and Grotius and the Swedes and the Germans and the French, the Dutch, even the Christian world was divided. The Protestants were very sure that the Catholics were not Christians. The Catholics were very sure the Protestants weren't Christians. And when the Protestant armies moved into a Catholic city, they killed all the Catholics. And when the Catholic armies moved into a city, they killed all the Protestants. And to the astonishment of all, there weren't many left. Over half of Germany was slaughtered during those wars. And so theologians, and he was one of them, and he's also a jurist like Grotius, began to ask whether or not there was a law that bound one Christian faith to another. And Grotius said yes, he thought there was. He thought that this law actually bound not only Protestants and Catholics, but it bound Muslims and Jews and Hindus and Confucians and the rest. And of course, he wrote those books, and much of what we're doing today is a legacy not only of the Spanish theologians, but of Grotius and the other ones in Northern Europe who began to develop the law of nations. Now, there was no customary international law. Customary international law is a newcomer. It developed in the late 19th centuries out of largely French positivism. I don't buy the definition of customary international law in the ICJ statute. It was put there. It never made any sense. There is no consistent state practice. You look out that window, though, you'll never see a state practicing. You may see people practicing, but you're not going to see France or Italy or anybody else practicing. This idea, belief that it was law, that was never true. So that statute put us in an intellectual and practical bind that some people have never escaped from. Don't look for it. It ain't there. What there was the law of nations. Now, the law of nations was different than treaties. Treaties has been around for more than 2,000 years. That's a compact between two greater than a person entities, be it a city-state, be it a province, be it a country. Those have been around for a long time. And for those of you like me who are a common lawyer, you know that common law recognized two separate subject matters, which are sort of part of our field. One of them was the law of treaties. The other one was the law of nations. And nobody really talked about customary international law. So we're not doing treaties. That's for another panel, perhaps. And treaties are the easier form of international law to understand. There may be a contract. They may be a statute. They may be a constitution. They may be aspirational. But whatever they are, they're a multi-usage form of international practice between city-states or countries or blah, blah, blah. What we're interested in is what is left. What's the problem with treaties? Well, one, it can't covers everything. Can't do everything. Two, not everybody is bound by them. So there are bound to be gaps in treaties. There are bound to be non-participants. Moreover, what do treaties matter? Why should treaties count? Why are treaties law? Well, the old notion, if you put it in Latin, you call it pacta sunt servanda. If you put it in English, it may be that treaties are binding. Says who? Says no one. It's not out there. Can't find it. You can't have a treaty on treaties like the Vienna Convention that says treaties are binding. That's a circular logic. A treaty says treaties are binding. Mark says that Mark is right. Go ahead, believe it if you will, but it doesn't really prove very much, does it? There's no foundation for treaties, which are the more sure form of international law, without something else. Now, what is the law of nations? And what I'm proposing to you, and I suggest you be naive and an idealist, is go back 500 years to the problems involving the indigenous Americans. Go back 500 years to the problems between the Catholics and the Protestants. And go back to the idealism and the aspirations of those theologians and those jurists at the time that there's just got to be something better than all this war and slaughter, all of this enslavement, all of this bad stuff going on. Now, the realists are going to tell you, no, they're not. That's just the basic aspect of human nature. Okay, fair enough. Buy it if you will. People are fundamentally evil. Okay, viable proposition. A lot of people live by that tenet. They do reasonably well in business and politics and law, dentistry, whatever you think. That's possible. But if you'd rather move away from this, why don't think about being an idealist? The idealism of the Spanish theologians and of Grotius and Gentili and those chappies in the 17th century was that there is a law of nations, a law that comes from all the nations. Now, I know most of you have read the Law of War and Peace in Latin. It's a gripping read, right? You enjoyed it. It was fun. No cases, no treaties, no cites to Brian Leopard or Mark Janus. All's the pity. What they're quoting are the Greek and Roman philosophers, and they're quoting religious texts. That's what they had. Now, we know that those were largely aspirational. Nothing about Aristotle or Plato or St. John or St. Mark that make them positive sources in the way that would be recognized by the Blue Book or anything that you could use before the US Supreme Court, right, at that point in time. But the idea behind the use of those is these sources, as they were, the older sources of international law, not the current sources, citing the Vienna Convention, citing the Clock Havana, something like that. Those are on the verge of being positive sources, very man-made sources, very reprehensible sources. But go to sources that might reflect universals, whether they're espoused religiously, it doesn't only have to be Christianity, whether or not it's espoused in terms of philosophy or logic, it doesn't only have to be the Greeks and the Romans, but something that would bind all humankind together. Now, I'm not saying that's perfect, because it ain't. It's not perfect. And I'm not saying it's easy, because there are so many sources out there. Wikipedia will just send you a tree, right? There's so many sources that you can do. Is it naive? Yes. Is it aspirational? Yes. But I think we're living at a time where if we're going to remedy some of these outstanding problems that Jocelyn and Alan and Brian have alluded to, plus all the problems we haven't alluded to. I don't know if anybody reads newspapers anymore or websites anymore, but there's a lot of awful things going on. They may not be quite as bad as they were in the 1500s and the 1600s, but they're pretty bad. Then we're going to need some optimism, and we're going to need some naivety, and we're going to need a search of a law of nations, which speak generally to many people everywhere, which can form an underlying basis for treaties and, yes, the narrow definition of customary international law, or jus cogens, or fundamental norms, whatever you want to do. But we need to try to rediscover that. And looking at this group here, I think I found it. So good luck. Get to it. You can find my email. Send me your results. Thank you.
All right, well, thank you, Mark, for that very challenging presentation, right? I mean, the first reality in the very existence of customary international law. So we have a lot to talk about. So before we move in, though, to the discussion phase with you, I just want to raise, this broad question of our panelists based on what you shared with me. So I'm going to try to do my best here to see if I can summarize, right, your theses, and then, I'll give you a minute or so to kind of respond. So Jocelyn, if I hear you correctly, you're maintaining, on the one hand, that customary international law has a critical role to play in continuing to reaffirm the unlawfulness of the slave trade as an independent crime, apart from slavery, and that really we need it as kind of this, how should we put it, this kind of global wisdom, if you will, that is longstanding and that we seem to have forgotten in drafting some relevant treaties like the Rome Statute. So it has that strength. On the other hand, I believe I also heard you say that we still need treaties because the Rome Statute, for example, is the basis on which obviously the ICC chooses crimes to prosecute, in fact, is empowered to prosecute them. And so without recognition in this fundamental treaty, the reality is the slave trade is often going to get unprosecuted and therefore continue to proliferate. So it's like you're recognizing both a strength and a limitation. And I'll give you a chance to respond to that interpretation in just a second. Alan, if I understood your points well, you noted that we have a variety of treaties that address child labor and a variety of agreements whereby actually we're trying to eliminate it, right, by 2025. And yet you're pointing out that it's very doubtful we have customary international law on the subject because in practice, so many states permit child labor and even adopt minimum ages that are far below the age of 18, which is really the desired age specified in these treaties. And so, and I also understand that you have some doubts about the whole enterprise of trying to eliminate child labor because of the reality, right, that children depend and their families depend on their productive labor. And so maybe you're challenging even the idea of having this standard, but trying to create whole new standards, which might take the form of a kind of new customary law where we accept some form of child labor, but say insist that it be in safe type of work for children. Okay. But that's a real limit of customary law, the fact that we have such wildly varying state practice that we can't even say there's one. And so you can react to that in just a second. And then if I understand Mark's point, well, my goodness, he would like to go back, and I have a lot of sympathy with this because one of the, I'll just say that I've written about the importance of introducing an ethical perspective in our analysis of what is customary international law, which can draw on teachings of the great world religions, which many of the founders of international law, like Grotius, actually drew some inspiration from, not as well as, of course, the founders of Islamic international law, which is very sophisticated, but then also, the great philosophers. And so, to the extent we can identify ethical principles, I have a lot of sympathy for that, because when we do rely solely on the practice of sovereign states to generate international law, we know the limitations. We're seeing those today. These states have their own self-interests that are often not coincident with the interests of humanity. So I think, I'm just wondering how you would react to the concept that maybe we don't have to throw custom international law out entirely, but what if we were to interpret it or identify it in relation to that law of nations that you focus on? So if you could just have a reaction. I'm sorry, I'll just kind of go in turn and give you a chance to react to that, and then we can turn to all of you and get your insights.
Okay, so I don't know if this is the reaction you were hoping for or would want, but in listening to my fellow panelists and in reaction to the statement that you made, what it says to me is that these discussions are really opening up the limitations of international law in a real critical way, and especially human rights law, which is we do not address settler colonialism, and we do not address racialized capitalism. And these two systems operate for the continuation of these practices that we're discussing today. And they began in the 500 years ago era, right? And our existing system of law does not squarely address those two very big problems that allow the perpetuation of subjugation, oppression, all the things that all of us who practice international human rights law care about. So I don't know if I have an answer, but what I'm hearing is, I don't even know if law of nations, because the Westphalian state model is problematic on a lot of regards when it comes to really thinking about equality and redress for economic harms like slave trade and child labor. The special advisor on slavery crimes with whom I work very closely, Patty Sellers, says to me, it's really hard to look a slave in the eye. And it is, because the systems of law that we have to address these very real problems that stem from our economic system that we are all functioning in, they're inadequate.
Thank you. So my reaction is, we need to move it out of the concept of law. The problems with child labor are economic and sociological. And to the extent that we try to cover that up, I think, as a legal matter, we must stop child labor. It's not ever going to work. Eric Edmonds, a great economist at Dartmouth, has been writing about this for decades, and he said, in Vietnam, there was huge child labor problems. The price of rice went up, so that the farmers could make more money by selling that rice. Child labor plummeted. It's all about the money. So there's no use talking about laws to stop child labor. We need laws to say families need to have an ability to survive. And to the point where last year, 4 of my students from Southeast Asia, from Sub-Saharan Africa, they said, if you came to our communities, like they're Canadian now, but back then, he said, if you came to our community and you said, you're going to get rid of child labor, you would be murdered. That's it. You're telling me you want my child to stop working so that I can't eat? I don't think so. So we see the depths of this issue that we're trying to cover over through the use of laws and human rights and business, and that's not going to work. We need to, fundamentally look at the economic problems and the sociological of how to get people up to the level where they can live. Because looking at Maslow's hierarchy, it's a little bit more important to be able to eat today than go to school. When we get them eating, then we can talk about education. So it's really not within the realm of law, from my perspective.
Thank you. Hey, Mark.
So I agree with Brian that it is an ethical issue. And I think what we're all agreed on is that it's okay talking about these things not only in an economic and sociological way, but in a moral and ethical way. I think both slavery and child labor are morally and ethically wrong. You may disagree. I understand different viewpoints on both. But I think we've got to go beyond customary international law in talking about the role of international lawyers. I think we've got to talk about bringing in ethical, religious, moral considerations into the prosecution of our trade. And I would say that international lawyers have done that for 500 years. Nothing wrong with it. Nothing wrong with it. So even though you may feel idealistic, or you may feel as if you're promoting a cause, appealing to the black letter legal rules, get on with it. It's okay to do that. And it's okay to enlist the aid of non-lawyers, people who couldn't tell use cogents from pactus sunt servanda, people who don't understand those Latin texts. They're still people. You don't have to know Latin to practice international law. Speak the cause and the ideals of international law in real language that appeals to real people. International law causes have been promoted more by non-lawyers than by lawyers. There's more of a community for that. Whatever culture you look in, whatever religious or ethical tradition you look in, many of the most important proponents of international law, many of the big changers in international law, don't have a law degree, aren't lawyers. And I think we should be willing, some of you, I don't know how they let you in, but some of you may be non-lawyers. And that's okay by me. It washes as far as I'm concerned. And I think we, as members, if you are a card-carrying lawyer, it's up to us to include those non-lawyers in our causes.
Well, thank you very much. I think we've heard some very insightful presentations by the panelists. And speaking of the benefits of getting insights from non-lawyers and even from lawyers from many different backgrounds and many different areas of practice, and we'd like to open it up now. And so I would like to invite questions for the panelists and or a brief comment that you can make. I would just urge you to keep your question and comment brief. And it would help if you would identify, if you do have some affiliation, that's great to know. So we're going to turn then to, okay, we have quite a few hands go up. Let's see if I got them. We'll start over here. Go ahead. And
hi, I'm Jessie. I'm a 2L at St. John's. So not yet a lawyer, but working on it. I guess it's kind of a comment and overall open question to the whole panel, but the comment was really to
Brian,
Alan.
can you pass a microphone over?
yeah, I was just thinking that would
sorry.
be a rope and
I can move it around.
oh,
for
thank
the
you so much.
students.
Thanks. Assuming that you heard everything I said so far, I wanted to respond to Alan's comment, but also kind of open it up as a general question to the rest of you for input as well. I guess I don't really see the difference in what you're saying from what everybody else is saying, regarding like an economic and sociological issue. I see this all as a legal issue. I mean, in undergrad, a political scholar once said like politics is who gets what, where, and or what, when, and how. And I mean, economic issues are legal issues, and sociological issues are legal issues, because at the end of the day, the only way to institutionalize the progress that we're going to make is through law, in large part, at least as practitioners. So I guess, what do you see as the potential for making positive, or what I would say positive law to change the realm of slave trade and child labor, and I guess the need for it, as what you were clearly pointing out, if we change with positive law to make circumstances better for people, while also making kind of customary international law to kind of negatively or like the negative law that would say you can't do this. So I guess open it up for that.
Thanks. Excellent question. For which I thank you. And I guess we go back to the fundamentals of international law, which is sovereignty. And that's where the problem starts. When the country can't say anything, so people, the leaders say, let the poor die, we don't care. We're not gonna open schools, we're gonna have public, they have private schools for the wealthy and nothing for the poor. You, as the leader, should be jailed, sent to the ICC for trial or whatever. You must lose your right to make those decisions because you're hurting your people. Perhaps that's one of the starting points, because in Cambodia, they have no schools, very few. The World Bank says to me, I said to the World Bank people, well, that's because they don't have money. They said, we've seen their financial statements for the government of Cambodia. Guess what? They got oodles of money. Mostly they're stealing it for themselves. But they're not putting it into these things. So that's where the problem starts. You can't legislate to say no child labor unless you want to legislate to say all children shall have the risk of death, and that's okay. Going back to Mark's point, right, of ethics. So that's why I don't see the law as being the fundamental in terms of, I think, what you were suggesting. Like we always say, business has to do this, they have to do due diligence and find the children and fire them. Well, you might as well just shoot the kids if you're gonna fire them, right? So until we come to an understanding of what this is really about from the economic and sociological perspective, where it's harming the children to use the legal process in that way. That's my response.
I was, in listening to your question, coming to the idea of the law must be stable, but it cannot stand still. I think Roscoe Pound said that or wrote that. I always take losing cases. And it's because I'm probably a little bit more in Mark's camp, where I think about what should the law be doing, rather than what does the law say. And yes, I still have to be a creative attorney because I am using the law to further rights, but at the same time, human rights is about ensuring that we have evolving standards, right? And that states are constantly improving dignity and justice for everyone on the ground within their borders. And so I would just encourage the thinking about, okay, as lawyers, we are upholding a system, and it is a system that wants to reinforce the status quo. And you can practice your entire career that way. Or you can say, I see injustice, I see how the law can be a tool for further emancipation or further justice, and that's where I'm going to concentrate my efforts. And that's what I encourage all of the young people to do, because we failed.
So let's take a look at another problem with treaties. Treaties are made by states. Now, you only have to read the newspaper, go on the web to realize how wicked states are, right? Not all the time, but generally states are not perfect. And if we count on states to be the principal or only legislators of international law, we're in for trouble, right? And international law has to go beyond the state-oriented structure. Not that states don't make a difference. Not that I don't keep looking out my window and hope to see Connecticut walk past someday. Ethically, I hope. But traditionally, international lawyers have been beyond the state. And we have to think of an input that we can provide as mere jurists to the form, the structure, the substance of international law beyond state practice. And the ICJ statute, 1919 to 1921, was written at a point in time by certain people who consciously, by vote, excluded natural law. It was a vote in a committee. If anybody served in the committee, you know how trustworthy they are. We don't have to live by that as international lawyers. If one of you is presently a member of the International Court of Justice, please raise your hand. Where'd you get this audience, Brian? None of you are bound by ICJ statute. The only people who are bound by that are the judges on the ICJ. The other 8 billion of us, including the 50 of us here, are free to do international law in our way. I can understand the attractiveness of using the ICJ statute as a teaching tool, because most states belong to the ICJ. It represents a consensus. It's been translated into many languages. It's okay. But international law,
I do use it, so my students are here, so.
and for jostling students, better than the rest of us. But anyway, I just ask you to think outside the bounds of the ICJ statute. There's nothing wrong, Brian, with customary international law. That's an important component of it. But it's not the only way to supplement and to buttress other rules like rules and treaties. And I would suggest the law of nations is not customary international law. Customary international law is not the law of nations. I think we should look beyond customary international law.
Thank you. Okay, we did have a couple other questions or comments here. So first we'll go here and was it Jaren? Turn it over. Okay, thanks. Oh, and then I'm here. All right.
Thank you so very much for your perspectives. I am Miron. I'm a Temple Law scholar. I just recently matriculated, and my question is specifically in respect to the fact that I really appreciate Mr. Janice's attempt to go outside of the scope of, say, the First World War, the Second World War, outside of what jurists usually impugn as the norms of our time, the institutions of our day, what really rules us and what we think about and reflect on when we practice law, and go all the way back. But to some extent, after World War II, we established a very strict set of mechanisms, a very strict set of rules, which we do aspire to. And is there a fear that in this era of the use of armed force, in this era of recognizing states that were just born 2 days ago, in this era of invasions and counter invasions, if we don't delimit ourselves in time to very specific provisions, to very specific aspirations, to very specific norms and rules, is there a fear that we could destroy the whole system in trying to advocate, trying to defend it?
Yeah, I mean, I feel the same way about the United Nations as I feel about the United States Constitution. I am 100% sure that given the present nature of these United States, we can never draft a new constitution. The whole thought of going back root and branch to a new constitution, it's not going to happen. And I feel the same about the United Nations Charter. I don't think if we went back to redo the United Nations Charter that it would work. I think we've got to, I'm all for going with the Constitution with all its flaws. I'm all for going with the United Nations Charter because we have it there. I'm talking more, and I'm not trying to ascribe to any of us, say perhaps Jocelyn students, the power to change these things. I don't think, with that exception, international lawyers are going to be able to be a threat to anything. Maybe the bar at the end of a conference, I don't know. But we're not going to be able to change it. I'm just talking about our role, what we should be doing to making our contribution. And to me, I think our contribution should have more to do with morals and ethics than it has been, though I think there's a good role for us to look at black letter law and do our best within the present court structures, the present diplomatic processes, and all the rest of it. Yes, we should do that, but I think more of us should spend more time with basic ethical and moral questions. That's all I'm asking. If any of you are powerful enough to uproot either the U.S. Constitution or the UN Charter, I would agree with you 100%. Don't do it. Save that for Jocelyn students.
Thanks. Okay, maybe we can go to
Thank you. Gonna make a comment and do the academic. What do you think? I appreciate Professor Janice's comments. And just thinking about this notion of customary international law that we have, I would offer perhaps a counter proposal as someone who identifies as a naive, idealistic practitioner of international law. I have viewed customary international law as the most idealistic, the most promising area of public international law, because I think it allows a venue to articulate for these moral, ethical norms that everybody recognizes this is bad, but in practice, states have so many different motives for contravening those ethical norms that we take for granted. So torture, which at this point, a use Kogan's norm, is probably the best example. Everybody generally agrees that we shouldn't torture, and yet states have various reasons for continuing to employ torture or sanctioning torture or just looking the other way when torture is employed. And then bringing this to talk about the environment and human rights, which came up in the committee conversation before, climate change. I think at this point, we as a society agree that it's important to combat climate change, to mitigate climate change, and to reduce our emissions. And yet countries have all these different political, economic reasons for continuing to sanction pollution, emissions of greenhouse gases. So this, what do you think that I was getting to is customary international law is really constrained by this idea of state practice. And we understand that there's a complete, it seems, divergence between, on the one hand, states, individuals recognizing that something is bad, and yet demanding that we see this state practice in order to say that something has reached the status of customary international law. So as international lawyers, shouldn't we be advocating for rethinking of this pillar of customary international law, the state practice that the ICJ and the general community has demanded in order to establish a customary international law norm?
Okay, well, Mark is pointing to me here. I'll just say, in my own writings, that is something that I've advocated for, is looking at state practice as evidence of opinio juris, but really seeing that, in my view, the essence of customary international law is and really has always been this desire to make a law, like make a rule, and that I view customary international law as a process of informal lawmaking to complement the formal lawmaking of treaties, and that the state practice, quote, requirement should not be viewed as this independent freestanding requirement, because frankly, how do you even, kind of like you talked about, what is state practice? Do you see, states outside the window? It's really hard. You could look at the same evidence of what states are doing and come to completely different interpretations of what the practice is, if there is any. And so it's a source of evidence of what states believe the law, and then in my theory, ought to be, but not in some distant future, but right now. And I do believe that actually most courts who try to ascertain customary international law are now moving in that direction and focusing on what we would call expressions of opinio juris and discounting state practice that's inconsistent with that opinio juris. And that's something that other scholars have documented as well. And so we can reconceptualize customary international law to be more like the kind of ethical law that I think Mark was talking about, and it's in line with, say, for example, the anti-slavery norm is a great example of an ethical norm that did embed itself gradually in state practice, eventually, but it clearly has an ethical foundation. And I think that's, so I would tend to agree with you. But there's also room, you may recall, even within the framework of Article 38 of the ICJ statute for, quote, general principles of law. And I think that also is an area where lawyers can be creative, including identifying what might be called general principles of law, which may bring us right back to the law of nations. And any other comments there?
Yeah, we sort of play a game within our community, right, the international lawyer. Because when you go back and take the ICJ reports, I think there's 74 cases where they canvassed 193 states as to what the practice is. Oh, wait a minute, there's 0. They've never done it. ICJ said it depends on the practice of states. They then tell you what the CIL is, but they don't ever look at what the states actually do because it's too much of work. The second is your reference to the torture. There's a convention against torture, that we all know. But when you have the major countries of the world, US, Russia, China, Saudi Arabia, all engaging in torture, you say it can't be used cogus because there's nobody who's actually complying with those rules in a CIL perspective. they pretend that they don't do it for not to get hit with the torture. But they don't actually believe that at all. There is no opinion of yours that you shouldn't torture. You shouldn't torture unless the person really deserves it. Like that's the idea, right? Or, well, he's a murderer, so it's okay to do it. So a lot of the bases of the CIL are, to me, just fantasies.
Just take a little issue. Because times states practice things in the breach, right? I mean, a lot of times we understand it's not okay to jaywalk. We do it all the time, or speed on a highway, that might be a better one. We do it all the time. We still understand that if we get a ticket, yeah, we're guilty, we have to pay the fine. So I actually would disagree that just looking at what states are doing isn't enough, right? It's what they're doing plus what do they think the law is. And even if they're practicing in the breach, but they still condemn torture, say, of other states, right? Even if they are conducting acts of torture, we can still point to the customary obligation of this state because you condemned all these other countries, you, even if you're practicing it, are doing it in the breach.
Thank you. I think we have time for one more question.
Thank you very much. I have a question to Professor Jenis, again, sorry. I want to ask about the interrelationship between use organs and the regime proposed by you of the law of nations. So how this, as I understood correctly, the smaller regime of use organs fits into the broader picture of the law of nations and which one is normally higher than the other, because from what I was told, use organs are normally of the highest value within the international legal order. So yeah.
Yeah, that's a question that sort of goes to the heart of the issue. What does use cogents mean? I mean, in Latin, it may mean compelling law, but as far as I'm aware, it didn't enter into the vocabulary of our discipline until just before the Second World War. And it seems to me that it was a substitute for the natural law that had gone missing in the 20s and the early 30s. That is, international lawyers and states were sort of optimistic. They thought that states would behave responsibly. And during the Second World War, it was felt that some states were not behaving particularly responsibly. And as far as I'm aware, I could be wrong, use cogents was the term invented by an Austrian jurist to object to some of the practices of Germany in the Anschluss about trying to incorporate Austria within the German Reich. But what he and others were talking about at the time were practices that were so fundamentally wrong that they undermined the nature of international law. So Verdros was talking about how no nation could sign away their sovereignty. He was interested in that. But he also talked about how the whole structure of international law would falter if you didn't believe treaties were binding, which was an old question. How can there be a law of treaties as law if, in fact, treaties are not binding? And he said that that had to be one of the fundamental norms. Those he called constitutional norms. My way of viewing it is that use cogents includes both those things, both rules against behavior that, in one sense or another, are outrageous. Don't incorporate Austria and Germany without Austria's free consent. And they can also encompass rules without which the regular international law system could not work. That is, if international obligations in written form between or among states aren't binding, then you don't have a ballgame. You know, it would probably help the New York Giants to field 15 players instead of 11 on any given day. You'd have a better chance of winning. But that would be the rules of the game. Unless you expect 15 players on both teams, you don't have a real ballgame. And that to me is what use cogents is about. I think it's been taken over in the past decades as sort of a substitute for fundamental norms or a substitute for natural law. But it can mean many things, but as compelling law, I think that's what it means. Others may have a different view.
You don't play baseball. No,
No, I was talking about football. I'm still reading for the documents.
We'll let this conversation continue afterwards. Before I invite you to thank our panelists, so I'll just let you know the CLE code for this presentation is lemur, Lemur, lemur. Okay, so please join me in thanking our panelists for their. Obviously, this is an ongoing conversation, so thank you.